Perfect. Okay. So we are recording. And I am just going to take a moment and introduce Lana to us. So we are very grateful for Lana spending some time with us today. She's going to talk about the social work role in the separation process. And Lana comes to us with a long history of experience in this area and a variety of different roles, both in the courtroom and in the social work profession. So she has created some non-court options for folks that are going through the separation process. And she's going to share a little bit more about that, as well as our, like I said, social work role in that. So we will leave it to Lana to take it away. I will be monitoring the chat as well. So if you have questions as we go, feel free to pop them in there, and I will, I'll bring those up when we have a minute to chat about, questions. So take it away, Lana. We're very grateful for your time.
Thanks, Holly. I appreciate the option to be able to come and speak to some colleagues. I know that I had reached out to Holly when I had gotten the notice about the SASW luncheons and offered the option of speaking about some of the changes that had happened in the world of separation and divorce, particularly how those affect or impact maybe social workers' practices or the clients that they deal with. And Holly was receptive to the idea of me sharing some information with you. I don't intend to have a really technical presentation for everyone today, but more so some information and education sharing about some modern changes that have happened in the world of separation and divorce that, as I had said, impact some social workers' practices. I'm not used to doing a lot of presentations with all of the screens off, and so I don't know, maybe if that's a practice, Holly, that most people, I see everyone actually has their screens off, that I'm just flipping through everyone here. I have no idea how many people have connected. Do you get a number there?
Yeah, we have about 52 screens. And there's sometimes we have folks with their cameras off because they are joining us while they're eating lunch. So
no problem.
Yeah.
I appreciate there's few of you who have put them on. That helps with the mirror neurons to be able to actually know that there is somebody on the other side of those screens. So I appreciate that. Thanks for doing that. I just wanted to be able to just share a bit about my background with you so that you can understand some of the context of why I am passionately wanting to spread the word about some education and information that I think is really relevant to all of our practices. I am currently regulated by my Bachelor of Social Work. I used to be a courtroom family law lawyer, and I have a history in pretty much everywhere where social work and the law can overlap. I have been a prosecutor for the Child and Family Services up in the Yukon. I spent 10 years there after having articled in Saskatchewan. Went to law school right after I had finished my Bachelor of Social Work. I had done a major practicum in the Children's Advocate Office. And for those of you who have maybe been around as long as I have, that was when Deb Parker Lowen was the child advocate. And I had done my major practicum there. And that really sparked a interest for me in the connection between law, policy, and social work. And I continued and got a law degree after that. Articled first in the corporate world, found out that nobody there had enough overlap in terms of the emotional intelligence that I wanted my colleagues to be able to have about some of the client issues. And I also did some criminal defense work with Legal Aid in Prince Albert before my husband and I relocated to the Yukon for 10 years. I was the director of counsel for the director of Family and Children's Services and territorially prosecuted up there, and started private practice with my husband after I left that in a firm there, and did private practice and helped operationalize the Child and Youth Advocate Office up in the Yukon. So we brought our 3 children home to Saskatchewan. My husband and I are both from here originally in 2014. And I did private practice here in the bar before opening up my own business here under my name, Lana Wickstrom, Separation Specialist. And I offer fully out-of-court services. And I believed so strongly in the need after my limited amount of time in Saskatchewan in the courtroom system here, as well as in addition to up in the Yukon. I've believe so fully in the need to move services out of court that I actually retired from the Law Society and took back my Bachelor of Social Work regulation, because at the time, back in 2016, there was no regulation in the form of mediation. And I didn't actually have to continue to have my law degree or law regulation. And I felt as though that was a bit of a back pocket to rely on that I didn't want to have. I really wanted to be able to have philosophically an entire practice that was forward thinking in terms of out of court action. As many of you likely know, across the country, we were one of the last provinces to have some changes that I want to talk to you about today that significantly can impact a lot of the populations that social workers deal with, and also some of our potentially expanded practice issues that I also wanted to talk to some of you about. If everyone knows how to use the chat function or the wave function, what I would just like to ask an open-ended question about the kinds of work that everyone in attendance, we've got, I think Holly, you said 52 screens. I'm just interested to know, if you wouldn't mind, could some of you, I'm just going to read as we go along. It would be helpful for me if I had some context about some of your practice areas and so some of the types or natures of client matters that you routinely deal with. So my assumption is that a lot of you may have connections to the counseling and therapy world, or have a practice that includes that. In addition to that, I'd like to understand some of the other areas, just so I can have some context about where separation and divorce might overlap with some of the practice matters.
We've actually had a number of more folks sign in, so we're at 63 screens.
Okay, great. Okay, great. So I'm seeing a lot of clinical counseling, primary healthcare, private counselor. Okay. Okay. So I'm going to guess that there is a significant percentage, 80% or more, who are offering direct client service delivery in terms of private practice counseling and therapy. And I think obviously everyone here, this is the joy of now speaking to the converted, of having a bachelor or a social work audience instead of a legal audience, to be able to have some overlap in terms of language and acumen. Obviously, I'm preaching to the converted to be able to understand that a significant amount of the people that we deal with as social workers on a daily basis have overlap with separation and divorce. What we know colloquially about the research that talks about separation and divorce is that it's one of the top 3 major life transitions. It's been spoken about to be able to happen to a person, second to the death of a spouse, the death of a child. It's a significant action or a significant life event that affects every aspect of our clients' functioning, or of our own. And so I thought it was a apt time in January to come and talk to the SASW about the changes in separation and divorce in Saskatchewan, because some of you may find an increase in your client service delivery, specifically about the issue of separation and divorce in January. January is historically known in the legal community and also in the social work community, or the counseling and therapy community, as Divorce Month. And that is because in many fields, certainly in my litigation practice and consistent in my current out of court practice, there are probably close to 3/4 more, or a 75% increase in the contacts I receive for support and assistance about a separation in January. That's often because January is a time where people create emotional resolutions, akin to how often people may say, this is the year I'm going to get fit and I'm going to get healthy. Many times people are making a resolution about saying, this is the year I'm going to do something about my existing marriage or about my existing common law relationship. It often is on the heels of, as many of you know, people saying, this is my one last Christmas for the children, or my one last time that I'm going to be spending as a family. And then in January, I'm going to start doing something about that. I can specifically indicate that between about the December 28th of every single year, the last 7 that I've had this business, and the usually about the third week of January, there is a radical increase in intakes that I receive throughout my website. So it is very consistent year over year that January is a month where we often see more intakes in terms of, or inquiries about separation and divorce. That the next time in the year is usually September, and that's often because that is not an actual but a more practical new year for a lot of people. They live in that semester system that still exists from a lot of our post-secondary education, and September is another time where you'll see also an increase in the prospect or the contemplation of separation and divorce for the population. So talking about this in January is quite relevant, and I wanted to be able to have an opportunity to give all of you who are often service providers for people in separation and divorce realms some information to better assist and better support and educate your clients if and when they are contemplating separation and divorce. And certainly that can be whether you're working with one client, the husband or the wife, and whether they're not married or not, the spouses, or whether you're working with one individual or the other. And I wanted to be able to have an opportunity to just canvas as well as we start. How many of you, now if we have close to 60 social workers here on the line, I'd just be interested to know how many of you even had heard of, even if you don't know the specifics or even if you don't know what it means, how many of you had ever even heard, hey, there are changes to how separation and divorce in Saskatchewan are functioning? Were there any people, and if you would be open to sharing that in the chat, I'm actually really interested in this because I have a personal grudge, I'd say, against how the dissemination of the information about this really significant change in Saskatchewan had happened, because I just really don't think that there's been enough information exchange or public information by the government from the changes, and I really would be interested to know if there was any portion from the existing population we've got here who was even aware. And I see a few people who have, yes, you had heard, but most, no, I haven't heard anything. Okay, not most, I would say getting some here. Okay. Yeah, and so this is pretty interesting to me as we're talking about a population from a professional standpoint that has had some significant opportunities even open up under this new legislation, even for professional work that you could offer as clients, but separate and apart from the professional work that you could potentially be expanding your service delivery into. We have the service delivery of our existing clients, and knowing that they're always a vulnerable population almost in every way that we're working with them, I think it's extremely important that we have some current and modern information and education to share with these people, even though we don't have the necessarily the obligation of being able to provide current information about the status of separation and divorce. I think that it certainly is of interest to a lot of social workers to be able to remain current and modern in terms of their understanding of a lot of the systems that social workers find themselves working in with client populations. So what I wanted to tell you and start to talk about is the changes in the laws that happened in July of 2022. Those were the changes that actually got put into place in July of 22. But truly, these changes in the laws about how people who are contemplating separation and divorce and where they should start out with services, they actually were passed back in 2019. And a lot of people will say to me, how can this be? How is this 5 years in the making? And we are just finding out about it. And I would say that that's just a function of poor dissemination of information from the government in terms of the changes that have made. And I think that it's really important for all of us to be able to have an idea about these changes, not necessarily be an expert in them and not necessarily be able to quote them, but to be familiar with the fact that there have been changes. And if after the hour today, the only thing that you remember is that woman said during that day, there were changes and I needed to be aware of changes, I think that that's enough progress for us to be able to say, hey, we've accomplished something. I just want to be able to help my fellow colleagues be live to the issue of the changes. So let's talk about what those changes are. So previously, prior to 2019, anyone who was separating or divorcing could, quote unquote, you know, hire a lawyer and file an application and go to court. I just got some feedback there, Holly. Can you figure out who that is?
My kiddo needs to
I think it's
volunteer.
Janice.
Got it, I think. Sorry.
Great. No, no problem at all. And prior to 2019, people who were separating and divorcing could reach out to a lawyer and initiate the process of separation and divorce by filling out the appropriate paperwork, having somebody served with an application, and then actually be able to get a court date, actually be able to trigger and intervene and have the participation of the legal system. And what has happened now is since July of 2022. So we're now almost 18 months, or we actually are 18 months into the changes. When people are separating and divorcing in Saskatchewan, they are not able to access the court system or the litigation system until they have something called a certificate. So the certificate is a requirement that all people in Saskatchewan who are contemplating or who are moving through the process of separation and divorce have to work with an out-of-court service provider. So it's an approved out-of-court service provider. And there are many different kinds of services, which is an important part for people to be able to understand. There aren't just one avenue, or there isn't just one avenue or one process available to people who are separating and divorcing now in Saskatchewan. So gone are the days of I just lawyer up, I hire a lawyer, I make an application and I go to court. We can't do that anymore. What we can do, or what we're required now to do, is start out in an out-of-court service with an approved service provider. So I want to be able to give you some tangible ways of finding this kind of information on your own if and when you have to be able to or want to be able to provide some information to a client who is separating or divorcing. So don't get caught in the weeds of what the laws are or what the legislation is or what number or what section. That's not the important part for the practice delivery, I don't think, from my perspective. My perspective is that the important part is you know that there are changes and you know how to direct somebody to the information so that they can make some more informed decisions, or so that you can find some better information on your own. So what I am going to do is just show you where you can find this information. So I should be share screening now. You should be able to see here this Saskatchewan residents and visitors. So if you are looking for information about this change in the laws in separation and divorce, what I want you to know is that it's as simple as going in, and even if you only remember one thing, mediation ministers list, mediation Saskatchewan, I just want to show you here, going into this web page for the Saskatchewan government will help you find information that's relevant to this topic. So we just discussed here, or I just shared with you, gone are the days where we just lawyer up, head to court, and don't have to have any attempts out of court to be able to deal with things. What you'll find here is a very short version on this website that says, in all Saskatchewan court jurisdictions, effective July 1st, family law matters that come to all family court will be required to attempt a family dispute resolution process by the close of pleadings before they can continue with any further court proceeding. Now, I don't want you to get caught in the weeds about what the legal definition of that is. I want you to know that yes, a client or yourselves, if you were experiencing a separation and divorce, you are able to reach out and connect with a lawyer. It's not that we don't use lawyers, it's that we're using them for their specific intended purpose. You can reach out, your clients can reach out and connect with a lawyer. Those lawyers are now obligated to share with clients or share with prospective clients that the changes in laws require them to be able to have a certificate if they need additional help. So starting off in the appropriate process with someone who is a professional or approved professional who can offer a client a certificate is the most effective and efficient way for people to start out attempting to deal with their issues arising from their separation and divorce. The reason why we want to be redirecting all people to an approved service provider who's able to provide a certificate is if somebody starts with a mediator, for example, who's somebody who calls themselves a mediator who is not on the minister's list or not on an approved service provider, what happens is if they work through and try to work through their issues and they hit a roadblock and they're not able to create a separation agreement or they're not able to finalize things, and then they do need additional assistance from a court, for example, what will happen is those clients who have spent their time, effort, energy, nervous system, regulation in trying to develop agreements inside of a service that is not able to provide them with a certificate, they are now going to be required to start over. So we already know we're dealing with a very taxed, overwhelmed population when we're talking about separation and divorce that is never alone in its issues in terms of whether or not there are dynamics present in that family already that are exacerbating the situation in terms of challenging issues that they're dealing with. We want to make sure that those vulnerable populations are getting good information and education up front. So that often means being able to help them just be aware and be alive to the fact that there are changes in the law that they should be connecting with and starting out with someone who is a qualified professional that can offer what's called a certificate of participation. So let's talk about the different kinds of professionals that are out there able to offer certificates. So I had mentioned that gone are the days where we just hire a lawyer and go to court. And now there are different process options that people who are separating and divorcing can choose from or can consider in creating or trying to create a separation agreement. So if we go just to this website page and we see here in the beginning, what I want you to go to or look at is this early family dispute resolution. This is what they're calling the requirement for the out of court work. And it's just the exact same notice here at this front page about the changes in the laws. And it will further explains here that recognized family mediators, family arbitrators, parenting coordinators, and collaborative lawyers set their own processes and fees. So this is giving information. This is kind of the first information that very, very narrowly litigated exemptions. And the narrowly litigated exemptions have all dealt with domestic violence to date. But the threshold of domestic violence or intimate partner violence that they have been narrowly holding the requirement for a certificate to are quite significant from my perspective. So it is not as though there are a broad range of exemptions that clients or that possible people can access. This is very much so a narrowing of the opportunities for people to get into a court system until they have participated in an out-of-court option. So if we look at the out-of-court options, I just also, as we're walking through these out-of-court options that we should be aware of if and when we have these clients who are looking or seeking information, or we're aware that this is their next step, I also want to highlight for all social workers where we also as professionals have opportunities to participate in offering these kinds of services. And this is something that potentially some social workers might consider expanding in terms of their service delivery options for clients. So if we just look onto here, there are some of these four options. What I wanted to start with is one that most people would be most familiar with, which is family mediation. And so most people are aware of the concept of mediation in their workplace or otherwise, where it's one neutral professional who is educated and informed about the topic area or the areas of interest that the people have challenges with, and they're supporting those two people to be able to have or create their own agreements about parenting, about support matters, and about property division matters. And I often am working in a mediation capacity with both, separating people and helping them to create a separation agreement on all the matters that arise as a result of their separation. And I'm often doing that in the role of a mediator. Prior to these laws coming into place, I didn't have to have, in Saskatchewan, it was an unregulated profession. Although I did have professional training and education to be able to support the expertise in offering those services, anyone could have called themselves a mediator. So now we have specific requirements for mediators, and I want you to be able to understand that social workers themselves are in the regulated, one of the regulated professions that are able to offer mediation services to prospective separating and divorcing clients. And there is a formalized process with formalized education and an actual application process that you have to go through in order to become a mediator. And the mediators that have done that, the mediators that have done the education and applied for his status, are all called approved service providers. And what you'll find here is it says, if you would like to find or recognize, I said approved, but it's recognized, my apologies, a recognized family mediator. The contact list is here. Now, this is not the most modern way that the government is identifying who is on the mediators list. But if you just if you press on this list on any given day, it's updated to see who may be on the minister's list. So I'm just going to show you here that as we look into the minister's list, what we have here is these are the recognized family mediators. So these are family mediators who have gone through, and it's actually quite extensive education requirements in order to be recognized under this King's Bench Act. Again, I don't want you to get caught up under legislation or under sections of legislation. I just want you to be remembering the concepts that are required with this. So here you can see that in these documents that are literally a PDF that somebody is inserting names to on a regular basis. It's not a live link or anything like that yet. We're working on that, not we, but they are working on that. And it's broken down into areas of the province where there are approved service providers who can offer mediation assistance. So what I want you to know is these mediators, as we're looking through this list, are a variety of backgrounds. So the backgrounds they have to be from have to include a regulatory body so that the vulnerable client populations that we're dealing with have some assurance of quality of service and some assurance of professional liability. So here we have, it's organized simply by area. And I'm just showing you that we have these service providers now here inside of Saskatchewan in all of these different regions who are qualified to be able to offer mediation services. So here we have under the Saskatoon, it's all just alphabetically, there's no magic to it, all of the service providers that are offered. The vast majority of the service providers on this list are from a legal background. So that means they are governed by the Law Society. That's the regulatory body that they're a member of. But there are a few of us who are not by trade lawyers. I'm certainly by trade a lawyer from before. I don't have that regulation. My regulation in order to be a social worker comes from being a member of the ADR Institute. And so there are certain specific requirements that we're required to have in terms of memberships and liabilities and liability insurance. The liability insurance that I use in order to qualify to be on the minister's list as a mediator is through the SASW. And so these people here, the vast majority of them are lawyers. However, there are some social workers and there are some financial professionals, and there are some people who are mediators in terms of their professional accreditation from different organizations. So if we just go back to family mediation here, what I can show you is just further on, if you were ever interested in finding out what you needed to do in order to become a family mediator, you can see here that there's actually an application form right on the website for information for any kind of professional that is interested in becoming a recognized family mediator. And you'll see down here that you must be a member in good standing of one of the following organizations here. And so this is where I had indicated that I'm a member of the ADR Institute of Saskatchewan, but there are some other members who certainly are certain other people on the minister's list that come from different one of these organizations here. You'll see that you must hold professional liability insurance that covers your practice as a mediator. The CASW insurance certainly provides that. And there is extensive requirements here. And so I don't want to bore you with any of these kind of requirements that you have to have. It does take about a 18-month period of time to 2 years period of time in order to schedule out, just based on the offerings, the ability to be able to get the kind of training and education that people are required to have. I just wanted you to be able to know how to access that if it is that you either had a client or you were interested in yourself in becoming a family mediator. I also wanted to show you too, if it was that you were looking for just a fact sheet or some information about the changes in the laws or information that you could share with a client, I just also wanted to show you here that here's a fact sheet that you could find online called the mandatory early dispute resolution in family law. And people are actually calling this MERD, which I refuse to call it MERD because nobody understands what you're speaking of, but that's the acronym for that. And it does just give a small summary of what is the early family dispute resolution, which just means, again, starting in one of these processes where somebody can give you a certificate if and when you ever needed to. And it just does describe that who could provide these services. It just indicates who is able to provide those services by making sure that anyone is on the approved list. So again, looking at that approved list, being able to simply search the words mediation and divorce will get you to this web page. It can give you the contact list of approved family law mediators. It can also give you the application form if you yourself as a professional were interested in doing so. It can also provide you with that fact sheet about the changes in the law and a very short summary about what those different processes are. So this is the most common process that most people are using in terms of mediation in order to help them create a separation agreement. It's important for you to know and be aware that those mediators are from different backgrounds. They're not always lawyers, and that's okay. There is legal training that's available from legal information, not legal advice standpoint, for all non-lawyers in order for them to become mediators. And that's part of the requirements if you are a non-lawyer who is applying to become a mediator. So I don't want you to be discouraged about not knowing enough about the law in order to try to pursue that. There's certainly information and training sessions available in order to satisfy those educational requirements for any social worker or any other non-legal professional. So this being the majority of work is often being done in my observation in family mediation. There are 3 other processes, and I wanted to highlight briefly the other 3 processes, not because I don't think that they're important, but I also wanted to help you understand that the vast majority of people are reaching out for mediation services. However, sometimes, and for a variety of reasons, maybe mediation isn't an appropriate service for them. Maybe they need some additional or more comprehensive assistance than what maybe a mediation process can offer. And I would introduce you, if you're not familiar with the collaborative divorce process. The collaborative divorce process is a transparent team that is created where there are 2 clients, and each of those clients have their own specifically and differently educated family law lawyers who support and assist those clients and one another as a team in order to address the issues arising from the separation. One of the aspects by contract that the collaborative divorce process has that is unique is that everyone on that team is signing a contract that says, we agree not to go to court, we agree not to threaten court. And in fact, if any of us pull out from this process, if either the separating parties pull out from the process, they in fact have to start over with new legal counsel if they want to pursue the court option. So that requirement, it's called a non-representation clause. That requirement is a cardinal aspect of collaborative divorce process that holds people in the container of out-of-court work, and it's held there by contract. And those contracts are certainly upheld by the Court of Queen's Bench previously and the Court of King's Bench that says if you've signed that collaborative divorce contract and you try to make a court application with that same lawyer, the court will reject the ability for that to be able, or the application of the law will reject the ability for that to happen and require you to hire different counsel. So certainly there's motivation, and that's the intentional transparent, and that's a transparent intention, is to motivate people to stay inside of that process. And also those contractual terms also create the ability for transparency, joint discussion, and team resolution to be able to find agreements that are going to be tolerable for both of the separating people. So the collaborative divorce process is a more comprehensive process than the mediation process. Sometimes for particular reasons in my practice, when I'm consulting with people, I will recommend that they are suitable, in my opinion, for mediation alone. And sometimes I am saying, actually, I think that these are more extensive issues, not always necessarily because of conflict or because of high conflict or acrimony, but maybe because of extensively complicated financial or corporate matters, potentially because they have some more sophisticated or dynamic issues arising from their separation that potentially mediation just isn't appropriate for on their own. And certainly every mediator will have their own comfort or their own tolerance for what kind of matters they think that they are able to work on their own, and where maybe they feel like additional assistance is needed. And that's certainly going to be a case-by-case basis for each different person. And so I'm sometimes recommending for clients that they consider the collaborative process, You can find information about the collaborative process here. You can find different professionals in the collaborative process as well for your clients here. And I just wanted to show you that under the Find a Professional, in the collaborative process, there are different practice areas. And just in this drop-down menu, you can see that certainly there's different players that can be involved in this collaborative divorce process by contract. And there are lawyers, of course, the separation and divorce coach that can be a social worker by the requirements of collaborative divorce process. Social workers are able to represent or to offer these kind of services, as well as a child specialist. And so a child specialist might be brought in by a separating couples team in order to provide some specific developmental assistance or child development assistance for a family who is struggling potentially with creating a parenting plan or parenting schedule that for some more unique or challenging dynamics. So I wanted to highlight that these are opportunities for social workers to be able to gain some education and qualifications in these areas, to be able to join these kind of team processes. Again, there's requirements for you to be able to take those education and training. In here, you can be able to see that there's upcoming, no upcoming professional training, apparently. There is a collaborative divorce process coming up in June, that there is a multidisciplinary training process. So I'm assuming that that will be up soon. But there's also a frequently asked questions here that you can refer clients to if you want them to be able to have more information and education on this. I also wanted you to be able to know too that they do provide some overview on some of the divorce options. So this might be helpful for some people who are wanting to take a look at, hey, what are those processes again? And I can't remember what they're named. You can look in here, and they do have a compare and contrast page here for the collaborative process, litigation in court, and mediation. And again, these are the three most common. The most common now, of course, as we had just discussed, being mediation for those processes. So this does give a different dynamic or a different unique prospects of different ones of those process. So it is just a resource that you can refer to if you're trying to collect some more information. Again, I just want to be able to give you a forest overview of what is out there, and to be able to go back to the initial page about early dispute. We've talked about that there's collaborative law process. That's what we just looked at. That's that specialized team that has that transparent contract to not go to court. We've talked about family mediation, which is often one person who is helping both people being able to create that agreement. And family arbitration here, and they all have their own drop-down menus. They all have their own contact list. So you can go into each one of those different profession or different options, and you can see the professionals that are approved. This is not something that social workers are able to offer if they don't have any other regulatory body to be able to join. Arbitration is not open to social workers to be able to be a part of, but I wanted you to be aware that this is a option, and it is arbitration is where people will try to mediate, try to be able to create their agreements on their own. However, if they're not able to, the person who is assisting can also create the or provide a ruling or provide a resolution on the outstanding issues. So I often describe this as like mini court to people, not to just to be able to help them connect that this person isn't a judge. The arbitrator is coming from a different professional background. It is not the court process. It is somebody who is able to, with their training and education, make a decision where people are unable to make those decisions. And so there is a formalized process again for family arbitration to be able to happen. What you do often see is people having an attempt at mediation, and if they aren't able to finalize all agreements in mediation, potentially then the arbitrator will decide on the outstanding issues. So that is also an option for people who are separating. And I just wanted to highlight again this fourth one, which is another area where social workers can participate as professionals, and it's called parenting coordination. So parenting coordination is where there are narrower issues. So parenting coordinators cannot speak to property division. They cannot speak to support issues or child support or spousal support for a family. They can only speak to a limited amount of parenting plan issues. So a parenting coordinator can only be involved with a family if they already have some preliminary aspects of their parenting already decided either by agreement or by a court. So it's not as though a parenting coordinator can come in and decide decision making, which is the current and modern term for custody. A parenting coordinator cannot decide whether or not somebody has a shared decision making or primary decision-making responsibility. They cannot do that. And they cannot set the parameters of the initial parenting schedule. For example, they cannot create the initial agreement about somebody being a primary a caregiver under what would be under the child support guidelines that more than 60% of the parenting time, and they cannot change the existing parenting schedule away from whether it's a equally shared parenting plan or a parenting plan where there's a primary caregiver. The parenting coordinator can't make those vast of changes. However, they can decide on, for families who are usually at increased or more high conflict cases, they can decide certain aspects of their parenting plan. So what we do see is parenting coordination being used in this jurisdiction, in other jurisdictions, for higher conflict matters. And certainly the caseload that you would be working with if you were a parenting coordinator. And I do see that we do have one parenting coordinator on this list. I'm just going to show you, if you would like to find a recognized parenting coordinator, you can go onto this list. And we do have, the rest of these are lawyers that I'm aware of, but here in Saskatoon, we do have Krista Shepherd, and I'm not sure, Shepherd Hills, pardon me. And I'm not sure, Krista, if you are on, I didn't see your name when I was scrolling, but you may have been one that had joined. So I'd be interested to know if they've had some parenting coordination interaction or had some client files. Certainly parenting coordination is a standalone profession now, where there is legislative requirements in order for you to get the education and training in order to become a parenting coordinator. But I wanted to highlight that this is one of the options open to social workers to consider and pursue. And again, all of that information for you to be able to look at on your own time if you wanted to is handled right inside of this website here. And there is an application form. You can see here that you must be a member in good standing of one of these organizations. You will see that the SASW is one of those, and that there is the list of extensive training that you're going to be able to have. And again, at the end of each one of these pages, it does have that PDF about the mandatory early family resolution requirements. So I'm just going to toggle back into the parenting coordination here. Original website here for the early family dispute resolution. And just to be able to circle back to the original thing that I had said is I don't want you to get caught up in needing to know or feeling as though you need to know what all of these processes are or the distinct or different features of them. I think it's important for you to know, again, hey, there's some changes that have happened in the laws. I know the old way of doing things is no longer the modern way of doing things. I know that, right? I want to encourage people to be aware and educated that there have been changes and that those changes are going to impact the efficient or the effective way that your either clients or colleagues are accessing the services that are available for separation and divorce, because we know we want to be inside of one of those services, because if we need additional help, if those clients need additional help from the court system, from the litigation system, they're going to need to be able to file a certificate from one of those professionals that say that they have had a genuine attempt at trying to create agreements. If they have that certificate, then they are able to make that kind of court application. Again, the door is closed. This is not something that they are kind of looking at implementing. I actually anticipated it would take about 12 months before it really solidified. It didn't. It was immediate. I think that there's been 3 exceptions. There's 2 reported cases. So it is tightly held, and people are being turned away and required to go back and try to work with somebody who can offer them a certificate, somebody who can offer them out of court work in order to attempt to resolve their matters outside of the court system or the legal system, for obvious reasons that I don't need to teach the converted. This audience is lovely to be able to understand that we all know that the litigation system isn't something that is healthy or that is a preferred alternative. We are now, modernizing the way that we support relationships breakdown to be able to understand that it is a relational issue. It's not a transactional issue, and that there are dynamic moving parts that are better served in out-of-court services. Certainly the sophistication of those out-of-court services are going to continue to evolve as we see the different loopholes that people are using or finding ways to use in this process. So like anything else, and it's in its very formative stages, there's definitely bumps on the road. There's definitely things that need to improve, but generally a movement away from just allowing people access to court systems is positive in my opinion. And we're going to continue to see some evolution on this, maybe not at the pace I want, but we're going to continue to see some evolution about the out-of-court services and how they're offered, and some potentially tighter understandings of who can offer and under what conditions. I'm also working on trying to get some uniformity amongst some of the service providers about how and when we offer certificates, but that's a whole other course for another day. So I just wanted to be able to provide this overview for all of you. I think it's really important for a lot of my colleagues to be able to have even a touch point to be able to say, right, I know that there's some changes here. I know I need to be alive to this. There's something going on. And even if you just remember that, I think that that's going to be a positive aspect of client service delivery for us, to be able to have that kind of professionalism about modern information in an area that so many of our clients often are interacting in. So that's the overview I wanted to be able to provide. Hopefully that there was some value in that, to be able to see where not only your clients might benefit from that, but also where you professionally could have some opportunities to expand service delivery for yourselves.
Thanks so much, Lana. We do have one question. I'm not sure if it's been answered yet or not, but the question is, can a lawyer issue a certificate of participation if the parties have reached an impasse after trying a mediator not on the ministry list?
Okay, so I'm going to try and find where that question is. Could you just repeat the question one more time?
Yeah, absolutely. So can a lawyer issue a certificate of participation if the parties have reached an impasse after trying a mediator not on the ministry list?
No, that cannot happen. So the only people who can issue the certificate, so the lawyer actually has zero capacity. No lawyer can issue any certificate unless they're a collaboratively trained lawyer and they were engaged in an actual collaborative contract and they actually started that process. So that is the only time any lawyer can offer that certificate outside of being a family arbitrator. So an individual lawyer who is just working under their law society regulation, if they do not have mediation, if they're not on the minister's list as a mediator and have offered services as a mediator, or if they aren't on the collaborative boards and have offered services. So it's not enough to be trained in the area and just work one-on-one with someone. You actually have to be trained in the area and have offered the service that you're trained in. So there is a lot of people, even lawyers, who are not practicing properly, who are exactly doing this. They're saying, well, I am a mediator, or the other person that I negotiated with or that I tried to negotiate with is on the minister's list, so we are able to get a certificate. That is not happening. People are required to be in the correct process with the correct professionals and have actually done that process.
Perfect, thanks. And there's just another question about finding the information about education required to become a service provider.
Right.
Would you be able to just copy the link into the chat maybe?
Sure. Here, I can do, and it's for any one of these processes that we talked about today. You can go in and you can press on any of those, and they have in the as you scroll towards the bottom, I can just share a screen again here. Here, any of these here, if you go into any of these processes right here, what you will find, pardon me, I'll go back in here. Where was I? Here we go. No, I'm just gonna pull up a new page. If you go right into the family meeting, right into early family dispute resolution, any of these processes here, right on the web page. If you scroll down to the bottom, it'll tell you here all of the contact lists that are available here for those processes. But what it also does is when you click into each one of these, for example, if you wanted to learn about okay, I am interested, I'm a social worker, I want to become potentially a mediator, how do I do that? You're going to go down into here. You're going to bypass this contact list because those are the people that are already on the list, although those would be good people to start with to get any kind of, hey, where did you go for your education? You could come down here, look on the application form, and the application form sets out what you are required to have and what they're going to accept in terms of requirements. But here are, right in the website, all of the requirements that you're required to have here. And for each one of those each one of these standalone regulated professions, you can go into each one of them on the website here, and it'll show you the same thing. Bypass that contact list. Those are people who have already gone on to there. And you come down here, you'll see the application form. You'll also see where the requirements in order to become a parenting coordinator are, for example.
Perfect. Thank you so much. There's been a lot of folks just echoing their thanks for your time today and for the information. We'll just do kind of a last call for questions. I know we're getting close to 1 o'clock, so we want to make sure that we give everyone time to run back to their days. But yeah, just kind of last call for questions. I'm not seeing anything. If there are any questions that come up for you after the presentation, feel free to reach out to our office and I can forward on any questions to Lana as well.
Perfect. And Holly, there's one thing that I just did want to mention before, and I've come across this now a few times, where in practice, whether by psychologists or by social workers, I have had a few clients come in and they said, we've been working with our social worker, or we've been working with our family therapist, or we've been working with our counselor on our separation agreement. And so I have had quite a few, an alarming amount actually, of people who are in the helping profession in a therapy or counseling role who are purporting to or holding out as though they are helping people to create a separation agreement. And I just want to make everyone be aware that if you are holding out as that, if you are using the term mediation, if you are trying to create that, that is a regulated profession now. So you are not able to do that. That's a liability issue for you. If you are in your counseling services trying to help people navigate, create brokerage agreements about parenting, support, and property, unless you are offering mediation services, unless you're offering parenting coordination, you are not able to do that. They will not be able to access the court system. If they say, well, my therapist agreed to continue to support us, my therapist was trying to help us stay in our relationship, our therapist now has said that they are going to help us continue to make our agreement. I have seen that quite a few times, and I just really wanted to make sure that everyone's aware that is not something inside of your role simply as a social worker that you're able to offer or hold out to offer. It is now a controlled title.
Good to know. Thank you for adding that. That's really important for us to be aware of. Oops. Clicked the wrong button on my end. Yes, we're so grateful for your time. That's all the questions I've gotten. Like I said, if there are questions that pop up for you after or other things like that, feel free to email our office and we will get the information to Lana. I'm not going to answer your questions. I will pass them on to Lana and then we will go from there and help you out as best we can. So thank you so much for everyone for taking the time, and we will see you next month for the next Lunch and Learn.
Thanks so much.
Have a good day, everyone.
Bye.
Thank you. Have a good day.